So what do you need to tidy all this up and make sure that everything that you want done gets done? So here are planning documents that everybody should have. Everyone should have a healthcare surrogate designation. And you need to have a backup to that person. You know, the person you're probably going to nominate first as your healthcare surrogate is someone you spend a lot of time with, and if you're in the same car wreck and in the same emergency room, you want a backup to that. So if that person is not available, you should have a backup. You should have a living will if you want one. I almost never encounter people who do not want a living will, and they're not that easy really to understand. In the simplest terms, what a living will says is that if I am at the end of life and 2 doctors verify that I am not going to recover, then I decline measures that just prolong my dying. If I'm not going to recover, no feeding tubes, no ventilators. For me, no IVs, no non-palliative surgery, turn off the pacemakers, let me go. That's what a living will is. The piece that's kind of confusing, and it came up early in COVID. We're all numb to COVID now. That's kind of sad. We shouldn't be, but we are. Me too. But when COVID first hit, it was, but what if I get COVID and I have a living will? Well, if a ventilator is treatment and you are likely going to recover, you get the treatment. Only after treatment fails and the doctors acknowledge that there's nothing more that can be done does a living will even come in. A living will is not a DNR. DNRs do not resuscitate. I get 40-year-olds come in my office and say, I want a DNR. And I say, really, I don't think you do. Because if you grab this electrical cord and your heart stops, CPR will bring you right back. You don't want that? Well, that's not what I mean. Yep. We confuse that. Do not resuscitate means if your heart stops, no one's going to do anything about it. So you don't want a DNR until you've already made the choice that you're not going to do any heroic measures, and if your heart stops, you're ready to depart. So, but if you do not have a living will, you will be Terry Shiloh. We will be arguing about what you wanted. So please write it down. Do a living will. Everyone needs a power of attorney. A power of attorney handles financial and contract matters. I have a personal philosophy about powers of attorney, about life plan documents in general. I think that they should be very broad and very powerful. The power of attorney in Florida is effective as soon as you sign it. It does not wait for you to be incapacitated. So, as soon as you sign it, if that person has it in their paw, they can use it. So is there a risk? Yes, there is. So we want to minimize that risk in several ways. First of all, the first line is, who are we going to choose to be named as the agent under the power of attorney? Let's choose someone who's completely trustable. And if we have any questions, let's appoint 2 and make them act together. And if you don't want to do that, then I and many attorneys will hold the original power of attorney for you. If people can't use what they don't have. So you have what I call an escrow letter that says, Dear Attorney Blackburn, you're holding my power of attorney. If I am incapacitated or I'm in the hospital or there are other good reasons, hand it over, otherwise you keep it. So we can also do that to keep it safe. But I think you should have one because we just don't know what could happen. And if you don't have capacity, we need someone who can sign for you. Everyone should have a will. People say, I don't have much. Why do I need a will? Okay, if you don't have much, you need a will more than people who have a lot. People who have a lot can pay for the fight over it. If you don't have a lot, all the pennies of what you do have is going to go to the fight over it. And if you think people won't fight over $5,000, you're not living in the real world. They will. And, even if, now, you say I don't have a will, but you do. And it's written by the state of Florida. And you may not like it. So, you should do a will. Even if, as we've already discussed, the reason to do one is to appoint somebody that you want to manage your estate. If you have minor children, we definitely want to do a nomination of guardian for the minors. That's done within a will. People ask me, if I'm married, do I still need these documents? Well, the healthcare surrogate, the spouse is the first surrogate. So you could get by for a while without one. Living will is not automatic, even if you're married. So if you're married, nothing helps you with the living will. Power of attorney is not automatic, even if you're married. Spouse can't go deal with your bank account. You need a power of attorney. In a will, in estates, your spouse has the first preference for the personal representative. The spouse will inherit 100% unless you have children who are not the children of the spouse, in which case the spouse gets half, the kids get half. Nomination of guardian for the minor. The other bio parent, of course, has the first right to be guardian. After that, you're going to have to fight about it. So, even if those automatic defaults are okay with you, consider this. Here you are. Here's your spouse. You go on like this for a long time, and then one of you passes, and it's just you. Now what? Now you're going to have to go out and do all these things that I told you today you should do. Right? And it actually is going to get worse. So consider this. Right? You're here. Your spouse is here. You pass away. Everything goes to your spouse. None of you did any of this. And now it goes to your spouse's blood family. So everybody who tells me I'm okay because I'm married, the minute I tell them this, they're, where do I get this done? Because this is what will happen. So you can't consider just today. And part of what I say to people is, in all likelihood, you're going to stay together for a very long time. And when one of you passes, it's going to be the worst day for the survivor. And do you want to run out and do life planning like that after you leave the funeral home, where you go through that agonizing process and they say it'll be $10,000, how will you pay today? No. So, everybody should do these things. At least these simple kinds of things. Now, there are some things, we have a question.
So, to get like a package plan, to get that whole thing, what does something like that cost? Your services, hey, I need you to do these whole lot of things.
I'm going to go over that a little bit differently, but so with me, if what you need is straightforward, there's no, we got to deal with disabled relatives and children and Medicaid planning and all this sort of thing, then the cost of the package of a healthcare surrogate, a living will, a power of attorney, a will, a nomination of guardian if you need it, and then something I'm going to go over, an appointment of agents for disposition of remains if you need it, is $750. If you come in the office and you sit down, you talk to me and Colleen about the details of that. If what you need is simple, and you already know who you want to appoint and who you want to be your beneficiaries, then you can go to another website that we started called mysimplelifeplan.com and fill out a form that puts all that information down, and it's $375. So I'm going to go over that again later, and then I have some brochures up here. So if you need the consultation to discuss the details of this, it's $750. If you already know, do the online form, and it's $375.
One more question. So you were talking about that power of attorney. Say
Yeah.
you don't have relatives or anyone who you can stuff to, you want your attorney, which would be you, to take over everything. Is that like extra from the $750?
Well, the question is, what if you don't really have anybody that you want to appoint and you want to appoint the attorney? A couple things about that. First of all, I'm not crazy about being that person because my practice is not set up to manage your banking and your affairs day to day. So what I usually recommend is that you appoint a professional fiduciary. Now they charge when they do the work. So there's no maintenance fees or things like that. And they do charge, so there has to be some funds to pay them, but you can appoint a professional fiduciary to do that. You can appoint friends. It doesn't have to be a relative.
What if you set up the will and things change and what it changes? How much does it cost to change the will?
It depends on how much does it cost to change a will is the question. If I did it, I have it on my computer. So if we think about it, it's not that hard to change. So the cost is not the same as originally. It just depends on what has to be done. If it's simply changing the name of your personal representative or something, the fee can be nominal, $100, $150. If it's more complex, it depends on what it is.
Just curious, would you change it yourself and have it notarized? Would that be legal?
Well, no, because a will, you can do it yourself. But a will has to be witnessed by two people, and if you do what's called a self-proving affidavit, which you should do, you have to have two people and a separate notary. So when I go and look at willsandtrusts.com, and their first selling point is you can get this signed at your convenience, let me just ask you, how convenient is it to find two witnesses and a notary in the same place? I've done it, and I don't think it's that convenient. So it's the execution of it that you have to get correct. And you cannot mark something out of a will and then initial it. You can't do that. That won't work. The original, excuse me, the original provision will apply. So you can't do that. Here's a document that some people should have. This is a designation of agent for disposition of remains. This is a lovely topic here. What do we do with you when you're no longer breathing? Okay. So somebody has to make those arrangements. And in Florida, that's governed by the funeral home statutes, and it falls to your blood family. So if you don't want your blood family making your final arrangements, we do this document that appoints somebody to do it.
What if you already have that set up? Nobody can change that, can they?
No one else can change it if you have it set up.
Like if you choose cremation, like I already got it all set up, someone can come and say, well, we're going to bury her instead.
Well, can somebody come and say, we're going to bury you when you already chose cremation and you had it set up? Now, I don't know what you mean by had it set up. If you prepaid it and prearrangement, no, it's over.
Okay.
That's what happens. That's the best thing to do. And in fact, prearranging your cremation or your burial is a gift. you give to the people you leave behind. Because they make one phone call and it's over. Question?
Not a question, but a comment. My mom passed away a little over a month ago, and I still have my dad, but we were just so blessed because they had everything put in place, prepaid, rearranged, the whole bit, and it made my sister and my life just that much more bearable to not have to even add on to, you know, everything else.
Exactly. Prearranging your final arrangements is truly a kind thing to do for people. I've done mine. And there's somebody who talks about these prearrangements on the internet. Let me see if I can get this right. Talking about sex doesn't make you pregnant any more than talking about cremation makes you dead. So we get superstitious about this, but it really is a kind thing to do for your family, because then when we do pass, our family and our friends can celebrate us, and they do not have to get stuck in making all those arrangements. But if you don't have it done, and even if you're inclined to do it, I understand human nature. I would do the designation of agent for disposition of remains, so we have that person taken care of. Some people should have a pre-need nomination of guardian. We've talked about that. Some people should have a revocable living trust. A trust is a document that will hold your assets now while you manage them, will continue to hold your assets if you are incapacitated, and the person you designate will manage your assets for your benefit as long as you're alive, and it will hold your assets and distribute them after you pass. So a revocable living trust does that for people. Some people should have business documents, such as bylaws or operating agreements. So a lot of people forget this. They go on SunBiz and they create their company, but they never do an operating agreement for their limited liability company or bylaws for their corporation, and they never think about how is that going to pass when they do. Some people need property documents, such as deeds or a land trust. Deeds can put joint owners on a property. We can, under some circumstances, add a beneficiary to a deed. A land trust will protect your investment properties from liability, and it will also, if you want to get anonymity, it'll give you anonymity. Some people need asset protection documents, some things to make sure that nobody can get at your assets. If you're concerned about that, we should talk about that. So why do you need these documents? And we've already talked about this, so I'm going to move through this pretty quickly. But if you think about it, if I'm ill or injured, who's going to go with me to the doctor or the hospital? Who's going to talk to the doctors and nurses if I can't? Who's going to tell my friends and my family how I am? Who's going to pay my bills? Who's going to take care of my pets? And how are they going to do that? So, if you don't have a designated healthcare surrogate, the answer is it's going to be your spouse or your blood family who's going to take care of your health care. Nobody's going to tell your friends unless your family lets them know. Nobody can pay your bills unless you have a power of attorney. And anyone can care for your pets if they're willing to steal them and pretend that they belong to them. So everyone should have a health care surrogate and the power of attorney. If you die, who's going to make your final arrangements? Who's going to pay your rent or mortgage? Who's going to dispose of your personal property? Who's going to sell or receive your home? Who's going to take care of your pets? Have you noticed that I'm trying to get you to pay attention to your pets? I just got stuck at a vet this morning with some 14-year-old cats that I'm fostering because their mommy died and their daddy had to go to a nursing home. So a rescue took them in and they were terrified in a cage, and so I said I would foster them. So, you know, unless you get the bleeding hearts, better you figure out what's going to happen to your pets. And how are they going to do that, right? If you don't have a will or a trust, again, all of this is going to fall to your blood family, or it's not going to happen at all. So, if I haven't made my point that I think everybody needs a will, let me try and make it again. Even with a will, you cannot disinherit your spouse. Your spouse is entitled to at least 30% of everything, plus a life estate in the homestead. Without a will, if you have children from another marriage or relationship, your spouse inherits 50%, and the children get 50%. If you don't have those children, the spouse gets 100%. With a will, as long as your spouse receives 30%, you can leave the rest to anybody you want to. If you do have no spouse or minor children, you can leave the assets to anybody or to any charity. Without a will, we're going to find blood relatives somewhere, and they're going to get it. People tell me I don't want the state to get my money. No, it's worse than that. It could be your fourth cousin, twice removed. I don't know do genealogy, so I don't know how we track those people down. But if you don't have a will, we might be. So these are the various kinds of documents for life planning. Just to put this in context, documents that apply only during your lifetime include a living will, that expires when you do, a health care surrogate, which expires when you do, a power of attorney, which expires when you do, and assets in your individual name are going to be frozen upon your death. Now, a will only applies after your death and after it is admitted to probate. The assets in your individual name are now going to pass under your will to your beneficiaries. If you want to know about the ever-popular avoiding probate, here it is. So these particular documents apply during your lifetime and after your death. So that includes an inter vivos or living trust, a revocable trust. That includes assets with joint names, because they will pass to the joint owner, and it includes assets with a beneficiary like life insurance. That will pass to the beneficiary, all outside of probate. If you want to avoid probate, you can put your assets in joint names. You can add a beneficiary to your assets, or you can create an inter vivos or living trust. In that case, they're all going to pass outside probate to the beneficiaries that you say.